अगर सिर्फ थोड़ा सा गाइडेंस अगर उनको मिल जाती है तो वो बहुत कुछ अचीव कर सकते हैं। हमने देखा है कि हमारे कुछ साथी अभी हाल फिलहाल में उन्होंने जुडिशरी ज्वाइन की है, सिर्फ और सिर्फ इसलिए क्योंकि उनको एक समय रहते हुए उनको एक दिशा मिली और एक सही डायरेक्शन में उनको एक डायरेक्शन मिली सही दिशा में, इस वजह से वो अचीव कर पाए। तो हमारा जो इसका जो ऑब्जेक्टिव है वही है, जो नीडी हैं, जो किसी वजह से, फीस की वजह से, पैसों की वजह से और टाइम की वजह से अपना अरेंजमेंट नहीं कर पाते हैं, तो ऐसे लोगों के लिए हमने कोशिश की है कि हम ऐसे लोगों को ये कोचिंग क्लास और जो जुडिशरी क्लास और कोचिंग क्लास हम दें। तो आज के प्रोग्राम में बहुत बहुत धन्यवाद, और इसके लिए मैं खासकर जो हमारे कन्वीनर हैं, एजुकेशन कमेटी के कन्वीनर श्री सुरेश, और हमारे साथी हैं श्री राव सर, मैं उनका विशेषकर धन्यवाद करना चाहता हूं कि उन्होंने बड़ी मेहनत के साथ ये प्रोग्राम डिजाइन किया है। और आज हम शुरुआत कर रहे हैं, आज हमारी पहली कोशिश है, और मुझे पूरी उम्मीद है कि ये हमारी कोशिश बेकार नहीं जाएगी। हम अपने ऑब्जेक्टिव में, हम अपने उद्देश्य में जरूर पूरे होंगे, और आने वाले समय में जैसे कि हमने पहले कहा कि हर फ्राइडे को हम ये क्लास करेंगे, और ये हमारा ये डिपेंड करेगा कि आप लोग कितना इसका फायदा उठा पाते हैं, कितना इंटरेस्ट दिखा पाते हैं, और अपने और साथियों को जो फाइनल ईयर में है या जो प्रैक्टिस कर रहे हैं, जो कोचिंग क्लास लेना चाहते हैं, जुड़ी क्लास में जो इंटरेस्टेड हैं, उनको कितना जोड़ पाते हैं। तो इसके साथ मैं अपने साथी जो सुरेश हैं, मैं उनसे कहना चाहता हूँ कि वो इस प्रोग्राम को आगे बढ़ाएं। बहुत बहुत धन्यवाद सभी साथियों को।
Thank you, General Secretary ji. Now I request Sri K.P. Rao sir, who is playing a key role in judicial AILU classes. He is a senior most advocate practicing from last 40 years in Delhi, various courts. He came forward to dedicate his time, contribute his time for the benefit of the students, aspirants of the judicial service. It is not a small thing nowadays. Contribution of time is very, giving time is very costly affair. So anyway, so AILU Delhi State Committee decided to conduct these classes, and Sri K.P. Rao has come forward. We know that every big successful issue also starts from small things. So irrespective of number and other things, it will get its gain in the future. Now I request Sri K.P. Rao to start his class by saying few things. Thereafter, record will be played. Sri K.P. Rao. Sri K. Prabhakar Rao.
Sir, my audio is not very much clear.
Well, now it is okay.
I welcome all the participants. Actually, today's class, I have already got it recorded, and the record will be played. My interest to conduct this class is that the aspirants of judiciary will get all the facilities, all the educational facilities to be successful in their examination. For that, we want to run the classes continuously at regular intervals, and the purpose of conducting these coaching classes is only to make the participants successful in the judiciary examinations, preliminary as well as main examinations, and also in the interview also we can give the tips, as well as we want to provide PDF files and PPT presentations to the participants. From the participants, we expect that they would canvass about this program in the coming 1 month, if there would be a substantial number of participants, then with that enthusiasm, we can contribute more and more. As I have said, that we want to supply the PDF files as well as PPT slides to the participants, which would be very much helpful for the preparation of judicial examination, multiple choice questions, and substantive detailed questions which would come in the main examination. For that also, we want to proper training. For that, in the chat box, you please give your email address as well as your WhatsApp number. Once substantial number of participants will come, we will start to supply PDF material as well as MCQs and quiz programs. Thank you very much. And I will hand over the mic to Sri Suresh, the convener of this program.
Thank you, sir. So while congratulating to KP Rao, now I am starting sharing his recorded video. Thereafter, if there is any questions, any doubts, few minutes it will be entertained. Sri KP Rao ji will give answers.
Suresh sir, why it is not audible? Not audible. Suresh sir, why it is not audible?
Sir, I am trying, sir.
You take the assistance of artificial intelligence.
Are
I will caution that once the answers in the output they artificial intelligence is quite often
माइक ऑन करना पड़े.
this our judiciary coaching classes will be bilingual. Most of the times I speak in English and at the same time, if possible, I will explain it in Hindi also. Okay? But once I told you the procedure, which I will do. But the procedure of what we have to add is three things. first thing is, if you are the final year student of LLB or BA LLB, how to spend at least 4 to 5 days. If you are in fourth year student, our study hours must be 3 to 4 hours. If you are a first year student, you spend 1 hour. That is more than enough. Continuously for the coming 5 years, we have to prepare for the judicial examination. Now, before the Honorable Supreme Court, the question who is eligible to give judicial examination is under consideration. If the court says that at least minimum 1 or 2 years of practice as an advocate is required, you cut down your study hours. So for that final year, students cut down your study hours. Instead of 4 to 5 hours, you spend only 3 hours. Why I am telling this? Once we start our course, within 1 year, we have to complete our course and retain it in our memory. But it is very difficult to keep it remaining in memory for a long time. It will create some health issues. That's why you start it and you complete it within 1 year, and between 1 year to 2 years, you have to qualify the examination. That is your task. It is also our task. Okay. Now, you must have got the periods, or otherwise, purchase the latest variant. If you have got already periods, in that you have marked this, you have highlighted some particular points, then you use that. If you did not have any variant and you have to purchase it, then you purchase the latest. Along with that, you have to purchase 3 highlighters. The first highlighter is to highlight the sections. The second highlighter is to highlight subsections. The third highlighter is to highlight provisos. Okay, because once you highlight in our variant, it will become very easy for you.
नेटवर्क खराब है इसका
to the sections.
कुछ मत करिए आप
Once colors will bring to our minds, that will become very easy to remember all these things. So follow this. Along with that thing, you always keep 3 notebooks. The first notebook is while I am teaching in the class, you mark your notes, whatever you like, whatever is interested, whatever may be the very interesting point to you, you note it down. The second one is particularly for the purpose of precedence. This notebook, we will use it once BNS I complete. In intervening time, I want to quote about the case law and other things. Once I complete BNS, about 40 to 50 cases are there. I will tell the chronological order and chapter wise, so that it will become very easy for you to remember. There is a method to remember case laws. That method I will teach you later. And another, the most important thing is, at least once we have to study the case law from top to bottom. After that, we have to remember writing this thing, this index. This index from section 1 to final section, whatever. For example, in BNS there are 358 sections. We have to see them at least once. And some of the most important sections, I will mark it up. And you can remember those. Similarly, in other acts also, we have to do my name is K. Prabhakar. I did my BSc from Andhra University, LLB from Delhi University, LLM from MUIT, and I am qualified in UGC NET That's why designated to be entitled to be as assistant with this small introduction without wasting the time. I straight away
मैं क्या करूँ आपको
BNS
गेस्ट पोस्ट बना देता है
BNS 2023. This is the first topic we are taking. We will take up chapter after chapter. The first chapter.
आपको होस्ट बनाते जूम मीटिंग में ऑटोमेटिकली ले लो नो चलेगा इसी तरह मैं आपको होस्ट बनाते ऑटोमेटिकली आप कंप्यूटर से ये चलेगा
The first chapter is
तो क्या बोलते हैं होस्ट बनाते
It is Bharatiya Nyaya Samhita 2023. We are not going to this particular first part because while explaining the preliminary chapter, I will talk about all these things. But these 2 points are very much important for you to note down. The presidential assent has been given on December 25th, 2023. This date is very important. Sometimes it may be given. And it has been come into force from July 1st, 2024. This is also very much. One particular subsection has not been brought into the force, that is section 106, subsection 2. About that later we will talk. But you just remember this thing. Section 106, subsection 2, it has not come into the force. It has not been notified. There are total 20 chapters and there are 358 sections. But we need not to remember all the 358 sections. But we should remember 20 chapter headlines. It is the most important thing. Whenever we pick up this particular act, we have to remember all the chapters and also from which section the chapter begins and from the end section of that particular chapter, we have to note it down in our memory. Okay. Now today's our class is about this general principles of criminal law. There are 5 essential ingredients in criminal law. The crime has not been defined anywhere, either in BNS or BNS. That's why what we do is crime we will understand in general sense which has been prohibited by law. If it is not prohibited by law, even though it is immoral for your moral considerations, then also it is not a crime. I will give 1 or 2 examples. 20 or 25 years back, domestic violence was not a crime. A spouse can beat another spouse. But once domestic violence act has come into the picture, violence against husband, violence against wife by the husband is prohibited by the law. That's why it has become crime. Similarly, you see, sexual harassment at workplace. At one particular point of time, it was not a crime. But once that act has come, Posh Act has come, now it has become a crime. That means crime is which has been prohibited by law. If it has not been prohibited by law, it is not a crime. For example, for your moral senses, living in relationship is not a property. but it is not a crime because it has not been prohibited by law. Similarly, for some people, intra-caste marriages are not to their taste. For them, that is immoral. But it is not a crime because our law did not prohibit intra-caste marriages or inter-religious marriages, and in fact, they encouraged it. When we will study Hindu Marriage Act, we will talk about this thing in detail. And now we will be coming that now we have understood what is a crime. Crime has got 5 ingredients. The first ingredient is person. Means the person who is offending. You may say in common language, criminal or accused. The offender who commits offense. An individual capable of committing a crime. It has been defined in section 226. Whenever I say 226, I am not saying to section 2, subsection 26. 226, you have to understand it is section 2, subsection 26. It has been defined, person includes any company or association or body of persons, whether incorporated or not. It is an inclusive definition. Definitions are 2 types. One is inclusive definition and the second one is exhaustive definition. It is inclusive definition. It means the things which are falling within these 4 corners of this definition also will come within the meaning of this definition. But in the case of exhaustive definition, the things those would come within the 4 corners of that particular definition, those have to be avoided. For example, you see here, person includes any company or association or body of persons whether incorporated or not. There are so many bodies which are not incorporated, or there may be not associations to commit offenses. Those are also come under person of the in detailed definition of this thing. Person, it is a very important aspect so far as judiciary examination is concerned. That's why when we talk about the first chapter delivery, I will go in depth of this definition and give certain examples also. But you have to simply remember this thing, that association or body of persons, whether incorporated or not, is also a person. It can do offense. It can be a criminal. It can be an accused. Now the question has come that our penal history says in the earlier stages, we have seen that mens rea. About that I will explain later. That mens rea, that mental thought process, guilty mind. If a company is there, a company is an inanimate body, it doesn't have its own life, then it doesn't have its own mind also and its own body, then how can it commit crime? That's why in the earlier days, whenever a corporation has committed an offense, it has not been punished. Gradually, the thought process has changed. That the corporation has got its own body. That's why it can be penalized by imposing fines and other things. But physical punishment, sentencing the corporation to the jail is not possible. That was the earlier. Later, that thing also has changed. A corporation or a body or a not incorporated body also will be led by some persons. Those persons are vicariously responsible for the offences committed by that particular corporation or by that particular company. That's why whenever a physical sentence has to be imposed on the body, their directors, their managing director or the chief functionary or any person who is responsible for that offense, he can be sentenced to imprisonment. That is the thing at present. So far, this person is concerned, later we will discuss. Next thing is mens area. It is the most important thing in this chapter. This mens area, all of you must have known, it is a guilty mind. Only first year or second year students might have heard this thing first time, or otherwise all of you may know. What is mens area? Ria means guilty. Mens matlab mind. You see, while studying mens area, it is a mental element, only mental thing. If anything behind anything that has gone in the mind with guilty intentions, then it is mens area. The thing is, it is a matter of fact. Whatever we do, without our mind says something, we don't do anything. Whether it is correct or not correct, a good thing, a benevolent thing, or whatever, normal routine things also. Everything it is controlled by mind. That's why mens area, later we will come. There are certain offences without a mens area, but that is not possible. Without having mental part of the body, nothing will happen. I cannot move this hand from this place to this place unless my mind controls it. That's why mens area you must understand that is the mental element or intention behind that mind. While studying this thing, I have already at the initial stage itself I told you. We are studying it in examination point of view. That's why two Latin maxims we have to remember. First is actus non facit reum nisi mes sit rea. Each and every word has got its own meaning, but it is similar to English. But you have to remember this particular legal maxim and its meaning, because in multiple choice this question will come. The meaning of this legal maxim is the intent and the act must both concur to constitute crime. If mind goes to left side and the action goes to right side, and it doesn't constitute a crime, both must concur for the offense. If there is a crime, the mind also thinks to do that crime, as well as the body also should do the crime, should do that particular crime. That means they must concur, intent and act. Well, I have written here the meaning of each and every word, but it is very easy to remember. Actus means act, non means not. Facet means it is a little bit different. Facet means meaning or causes. Ryu, guilty person or offender. Nisi, unless. It is very important word for us. Mens, it is mind. Sit is a man, it is his or be. Ria is guilty or a criminal conduct. Okay. Mens ria matlab mind guilty mind. Okay. Now second maxim which is very much important for us is actus me in vitro factus non est mens actus. Yeah, the act done by me against my will is not an act. Sometimes unconsciously we will do some crimes, or for various reasons we will do those crimes, but that a criminal intention is not there in our mind while doing that particular act. This legal maxim is explaining this thing. If against my will I will do a crime, it is not a crime, it is not an offense. I will give you two examples. If I have been forcibly given a drink, hard drink, liquor, and during that intoxication I will do something wrong, it is not an offense, because I did not have that will while I was doing that crime. That is one example, or otherwise. And the second example I will give you. I am a locksmith. I can open any lock. But I am doing my business only sitting on the pavement, on the sidewalk, and I am making the duplicate keys and other things. I am a very honest person. But one night, some robbers come and knock my door and forcibly take me to some mansion, some a very big house, and ask me to break open the locks of that particular house. I have been forced against my will. I break open those locks. Then this illegal vaccine comes. Okay, you remember these two examples. Actus in vitro factors, honest amongst factors. As a matter of fact, we have to remember 20 to 25 legal maxims. Most of the legal maxims come in general exceptions chapter 3 of BNS. There also, I will tell you these legal maxims. But once I complete this BNS, I will give you the list of 25 to 30 legal maxims, which are very important. They come quite often in the examinations. And the law of torts, those legal maxims come. Okay. Now, here also I have given the meaning of each and every word. Me in vitro, it means against my will. It is very important. Factors done, non-est is not. Mens actus by act. Mens actus by act. Okay. Difference between intention, recklessness, motive, and negligence. Once we are talking about mens rea, we have got 4 different shades of mens rea. Intention is there. Guilty intention is mens rea. Sometimes we do things with recklessness. It is also an offense. There, in the recklessness, in the act of recklessness, we know what will happen at the end of the act. We have got knowledge of that particular thing. But we don't have any guilty mind. That recklessness, oh, let it happen. We don't want it. But we don't have any guilty thing that it has to happen like this. That means recklessness. That is not a serious offense, but still it is an offense. And next we will go to the negligence. In the case of negligence, we don't know what will happen at the end of the act. Nor it is there. Neither criminal intention is there, nor we will foresee, nor we will see what will happen at the end of the action. You have to understand the difference between recklessness and negligence. In the recklessness, we will see what will happen at the end of the action. But in the negligence, we don't see what will happen at the end of the action. But in both the cases, we don't have any guilty mind. But in the case of intention, we have got guilty mind. Next to foresight, next we will come motive. It comes quite often. What is a motive? Motives may be very pure, or motives may be very ill motives, very bad motives. Even good motives also initiate criminal intentions. It is a key to the intention. Suppose I want to feed all the poor children in my colony. I don't have the money. What could I do? I plan a robbery from a rich person's house. I go to house. I go to his house in the night and I rob and I bring that amount with the amount with the pious intention, with a good motive. I will purchase the food and other things and I will distribute it to the poor children. Here my motive is very pure. Even then, I committed an offense. That's why
your motive is irrelevant so far as offense is concerned, whether it is good motive or bad motive. If offense is committed, it is an offense. That's why whenever we consider, motive is not a particular thing. We have to consider so far as offense is concerned. But police, while investigating the crime, try to find out the motive, because ill motive is the key to find out the intention. And intention is a mental fact which cannot be deciphered, which cannot be seen with the naked eyes. Only the intention propels some action. Only through the action we will put a step backward and try to find out what is there in the intention. Now we have understood what is intention, recklessness, motive, and negligence. It is somewhat important point for us to consider in the judiciary examination. Okay. Now, mens rea is not a very, very, very essential thing in each and every offense so far as India is concerned. English position is somewhat different, and Indian position is somewhat different. I have already promised you, I don't explain all those things. If my purpose is only to make you understand what questions will come in the judiciary examination. That's why I don't go what is happening in UK or US. Here, in our BNS, what we try to find out whether mens rea is there or not in that particular offense, we will try to find out these words in the particular provision. Intentionally, dishonestly, it has been defined in section 2.7. Fraudulently, it is in section 2.9. Knowledge, etc. This knowledge is there. Even though you do not have any intention, if your action gives evil consequences, and that you know, that knowledge is there in your mind, that is enough. Criminal intention is not required. If you use sufficient force to break a leg of a person, you have got that knowledge, that force is quite enough to break his leg. Even though you don't have any mens rea, criminal intention, that knowledge is more than enough to convict you. Knowledge is also a particular word from which we backtrack to find out the guilty mind. I have already told you, without mind suggests, we will do nothing. Even though we use quite sufficient force against a person, that force is being applied only after our mind has ordered our body to do that thing. Even then, for the purpose of easy understanding, we say, even though criminal intention is there, that knowledge that may cause that particular action will result into evil consequence, that is enough to make it an offense. Okay. Now we will look at it. This is the very most important part, because questions time and again, subjective questions are coming on this particular part. In BNS and earlier version in Indian Penal Code also, mens rea is not essential in certain criminal laws as well as in BNS. Without having criminal intention, if offense is proved, he can be convicted. It doesn't mean that you have done an act without your mind ordering that thing. Its meaning is that the prosecution shall not be burdened that it has to prove mens rea in those cases. What are those cases? Socio-economic offenses. Food Adulteration Act, Weights and Measurements Act, etc. In these acts, if an offense is committed, prosecution need not to bother that he has got a criminal intention. There are some very important landmark judgments which say that in socio-economic offenses, mens rea is not important. And in some cases, some landmark cases are there where court itself said, no, in these cases, even in the socio-economic offenses, mens rea has to be proved. But we have to understand for the purpose of judiciary examination in socio-economic offenses, counterfeiting and other things of kinds. In these, so mens rea is not required. Now, for the prosecution to prove mens rea is not required. Okay, and other offenses, war against state, sedition, counterfeiting of kinds, rape, etc. In these also, that mens rea is not required. For example, you see rape. Rape is it that only can be done only with guilty mind. Without a guilty mind, one person cannot commit rape. Even then, our law is saying, in the case of rape, you need not to prove that a mens rea. If you prove only just that rape has happened, why it has happened, why this criminal injustice is there in the accused mind and all the things.
अलग अलग 27 खाने बने हुए थानों में राजा की ड्यूटी बैठकर 27 घाटों का अकाउंट यानी कि हिसाब किताब इसीलिए 27 कहा जाता है
defamation cases, contempt of court. In these cases also, mens rea is not required. Next, fourth is offences where the proceedings are criminal in nature, but it is really a mode of enforcing a civil right. Traffic regulations. In the traffic regulations, etc. also, we need not to prove that mens rea is there. These are four types of cases you have to remember, because in subjective type of cases, the question will come, mens rea is not required in certain cases. Where kindly describe those cases where mens rea is not required. Such type of questions come. Okay. Next, actus. That means that the action part. That once the mind says that physical body will do that. Without a physical body, nothing will happen. Even though that guilty mind is there in the mind, nothing will happen as long as body will not cooperate. A paralytic person lying in the bed thinks so many bad things about his own family members, but he cannot do anything because his physical body is not cooperating with him. That's why actus reus is also very much important thing. This is the physical part of the crime. Next, fourth is injury. That some injury has to be happened. Otherwise, offense is not there. Okay. What is this injury? Injury is 4 types. Injury to the body, injury to the mind, injury to the reputation, or injury to the property. These are simple. The body, mental harassment. In the case of divorce cases, wife can file a spouse can file a case. Either wife or husband can file a case saying that a spouse has mentally harassed him or her. Okay, that reputation. Reputation is the most important thing one person can develop throughout his life. If any damage will happen, it is equivalent to harm to the body as well as to the mind. And in the case of reputation, even the dead persons have got the reputation. This is very much important. Quite often, we see so many leaders say so many bad things about the persons who died like that. They cannot defend themselves. But to keep their reputation intact is the responsibility of every living person. That's why if any person says any bad thing about Mahatma Gandhi, about Lenin, or any important personality, his reputation is being damaged. It is an injury. That's why it is an offense. We can approach the court seeking damages for that repetition. And next thing is the property. Property is the very important thing so far as BNS is concerned. That's why chapter 17 has been completely allocated for this property. Okay. Any harm caused to the property is an offense. Next thing, object. Object means any person who has suffered any loss or injury caused by reason of the act or omission of the accused person includes the guardian or legal agent. You simply understand victim is the object. Sometimes objects are inanimate also, property and other things. Okay. Sometimes victim dies. Her legal aids or his legal aids are also objects. They can claim compensation, damages, or they can pursue the criminal cases. Okay. These are the 5 important ingredients. These things you have to remember. Later on, while we will do MCQs, we can understand all this. Okay. There also I will ask these concepts. Now, again, one subjective type of question comes in this thing. There are 4 stages of crime. One is intention. That is mental contemplation.
7 minutes.
That is equivalent to mensoria. Intention is important. This is the first stage. But so far as crime is concerned, I have already explained you. Mensoria or criminal intention is not punishable so far as it is limited to criminal intention. Okay. Mere thoughts or intentions are not criminalized. They are not penalized. They become relevant only when manifested through actions. Once criminal intention plays active role in the action, then only criminal intention will be an offense. May be inferred from circumstances and conduct. Okay. In criminal intention, it happens only in the mind. It cannot be seen. It is not tangible. That's why whatever the action perpetrates through the mind, that from that action only, we will try to understand, to decipher, to take it out from the mind that criminal intention is there. Okay. Next, second one is preparation. In the preparation, once criminal intention comes, then it propels to do certain preparation. Arranging means वो क्राइम करने के लिए जो भी चीजें चाहिए होता है, जो भी चीजें जरूरी है, वो चीजें जो है इकट्ठे करना है. सपोज मर्डर करना है, चाकू छुरी के लिए ढूंढ डालना है, और अदरवाइज आग लगाना है, पेट्रोल वगैरह ढूंढना है. ये जो चीजें जो है, all this stuff is to the preparation. This is taking preliminary steps to commit a crime. What is the legal status so far as preparation is concerned? It is not a punishment. General. The 90% of the cases it is not punishment. But in certain specific cases, if criminal law says it is punishable even that preparation, then only it is punishable. What are those 2 examples we have? Making or possessing instruments or materials for forging or counterfeiting coin, government stamp, currency notes, or bank notes. This is the thing. This is punishable. Second thing is preparation to commit a crime. It is very important. Time and again, several times comes, at least 10 to 15 times it has come. Preparation to commit dacoity is itself an offense. Not only doing the dacoity, not only assembling for the dacoity, even for the preparation to commit dacoity is also an offense. It is in section 310. Okay. And the counterfeiting crimes, it comes under section 181. Attempt. After preparation has been done, direct movement towards commission of crime after preparation. These are also called inchoate crimes. Directly in the subjective question, they may put this inchoate crimes, describe inchoate crimes, that means attempt crimes. Interlegal status. The legal status of attempt is concerned, it is punishable under BNS. Not only this, IPS also it is punishable. What is that? Section 62, general provision for attempt to commit offences. Okay. Under section 62, that section says, if attempt to commit an offence is punishable and the sentence has been prescribed under the law, the court has to impose such sentence. If in the absence of any sentence in the statute, then if attempt will be done, then the general provision says half of the punishment that is imposed to commit offence will be imposed against the person who attempted to commit that offence. That means attempt to commit offence attracts half of the punishment for which offence punishment for the offence has been prescribed. Okay, this section 62 says this. That means each and every attempt is punishable. If it is prescribed by the law, that punishment will be. If it is not prescribed, half of the punishment prescribed for the offence will be imposed. Next attempt. It is once crime is completed, that is there in the book. Whatever may be the sentence prescribed there, that will be imposed. Think accomplishment, all the elements will be there. Mens rea is there, that preparation is there, and harm or injury has been occurred. Maximum punishment prescribed in the respective section applies. Examples include section 103. 103 is the completion of murder. Okay. 103, 104. Now we will see section 110, attempt to commit culpable homicide, and section 109, attempt to murder. Actually, in the BNS itself, these sections have provided if without doing murder, only you attempt, then this much of sentence will be imposed against you. Similarly, in the case of section 110. Okay, this is the thing as far as the descriptive part is concerned. Now we will go to the multiple choice questions. That I will explain it in the next. Okay, thank you.
Friends, now we have seen the recorded class of Sri K.P. Rao on BNS first for elementary aspects. If there are any questions, he will answer for a few minutes. Any doubts? Because this is first class, and beginning initial hurdles are there. Now we understood how to play this record and videos and other things. So next class onwards, these initial problems may not come. Okay. Yeah. Are there any questions? Otherwise, so our General Secretary Sunil ji will entrust the task of vote of thanks to some our AILU leaders. सुनील जी, आप है?
ठीक है सुरेश जी, आपने कर दिया माइंड अप, ठीक है। नेक्स्ट टाइम हम कोशिश करेंगे थोड़ा सा जो वॉइस क्वालिटी है उसको थोड़ा सा इम्प्रूव करने का। तो नेक्स्ट वीक हम मिलते हैं दोबारा से। पार्टिसिपेंट
Okay.
Okay.
So can I close now?
Yes, 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 please, please.
Friends, this meeting is being ended, and next week information, that is continuation of the BNS part 2, will inform any. Or sir? Thank you.